A potential client called my office and asked, what if I'm partially at fault? Can I still get money from an insurance company, or do I not have a case? And in California, the law is something called comparative fault. So if you imagine a pie chart and that whole pie is the entirety of all who could be at fault, there can be slices of that pie, as many parties as there are liable. So you can have 5 different defendants or 5 different actors, and each of them could be partially responsible. Many times when we have a truck accident or we have multi-vehicle accidents with different entities, business corporations or actors of the state, state entities like Caltrans or CHP or highway construction companies, there's a lot of different ways that different defendants can be liable. And so it's very important from the beginning that you have a lawyer that understands that nuance and can make sure that they bring in every party who is potentially liable. Because if they don't do that, they're missing out on sometimes potentially your best award, and they're also missing out on, at trial, there's going to be something called an empty chair, where all the defendants are going to be pointing to this other person who's not in the case. And unless you've gotten paid out by that person and they've settled out in what's called a good faith determination, you're going to have an issue at trial. And so it's very important that from the beginning in California, even if you are partially at fault, that you talk to an attorney to find out if there's other actors who have fault and what the law is going to do in your case. Each case is different, and it requires a careful analysis of all the different actors. And I don't mean movie actors, I mean defendants or people who are involved in the case. All those different actors have to be determined what assessment of liability they share. And if they do have liability, they have to be brought into a lawsuit, and that's just the way it works. So if you have any questions, give us a call.